My name is Barry Wood. I'm the Assessment Division Director for the DLGF. And today we're going to be talking about appeals and the PTABOA. And this is one of the topics from an assessment division perspective. We get many questions, it seems like, from either taxpayers or assessors or other local officials about the appeals and the PTABOA actions and whatnot. So first, the disclaimer. As you can see, this presentation and other Department of Local Government Finance materials are not a substitute for the law. The following is not legal advice, just an informative presentation. The Indiana Code always governs. And I may add to that disclaimer that our office does not get involved in individual assessment or appeal issues. If a taxpayer were to reach out to us, we try and help them as best as possible, or local official as much as possible. But the reason we don't get involved in assessment or appeal issues, typically we only hear one side of the story, and there are obviously two sides to the story. And also the way the system is, the appeal process is designed, it's handled or administered first at the local level, and then if a taxpayer does not agree with the determination at the local level, they can appeal to the Indiana Board of Tax Review. So we try and be as helpful as possible, but please note that if you have any specific appeal or assessment questions, or a taxpayer did, we would not be able to intervene or be involved in the final determination for that appeal or that assessment. So having said that, today we're going to cover appeals, legislative changes, the PTABOA role and responsibility, common issues and best practices that occur, and then questions. And so for those of you that may have been at the assessor conference last month, a lot of the information that, or not a lot, but some of the information that was presented in the PTABOA session, I will be repeating or reiterating, but it certainly is a different class and type of class from the assessor conference. But don't fear, you still get credit, continuing education credit for both the assessor conference class and this webinar today. So for those that may not be familiar, hopefully everybody is, but in case you aren't, the Form 130 is the appeal form that taxpayers use to appeal their assessment. And just to make sure everybody's aware, there are two types of appeals that a taxpayer can file. The first is a subjective appeal, and the second is an objective appeal. Those are both filed using the Form 130. And the appeal process, as you can see, starts at the local level, and unless the PTABOA fails to address the issue within 180 days, it ends at the local level and then on to the IBTR. So a taxpayer can file an appeal regarding an objective issue. And the way I look at it, objective issues, be it, say, square footage is wrong, or there's an incorrect description, or something along those lines, can it be answered with a simple yes or no, or true or false? For example, is the square footage wrong? Yes or no? Or is the home have a brick siding, yes or no, or true or false? So those would be objective appeals. Subjective appeals would be something where the taxpayer says, I believe my assessment is too high. That's a subjective determination and not an objective determination. A subjective appeal could not be answered with a simple yes or no, or true or false. On Form 130 on page 2, where a taxpayer files the objective appeals, you can see that they can be filed for a couple of different reasons. One, if the assessment was against the wrong person, if there is an issue with the deduction or an exemption or an abatement or a tax cap, if there was a clerical or mathematical mistake or error, the description of the property, or the legality or constitutionality of the property tax or assessment. In terms of timing, for objective appeals, they can be made up to 3 years after the taxes were first due and payable. However, if a taxpayer does request a refund, they would have to also file Form 17T along with the Form 130. In regard to appeals and how they're processed, it starts with the preliminary meeting. And by that, the assessor reaches out to the taxpayer to schedule a preliminary conference. And that preliminary conference can be in person, it can be virtual, it can be over the phone. There's no set procedure or requirement that the preliminary conference has to be held in person. And especially if you think back to COVID days, virtual hearings, I think, were the way everybody conducted themselves. But the assessor should be reaching out to the taxpayer to schedule a preliminary conference. Prior to that preliminary conference, the assessor and the taxpayer should be exchanging the information that they're going to use in the appeal process. And we'll talk about various pieces of evidence in the appeal process a little bit later. If for whatever reason either party obtains additional information after the preliminary conference, but before the PTABOA hearing, just a matter of course, that information must be given to the other party. Hopefully the appeal will detail the reasons why the assessor or the taxpayer is disputing the assessment. The taxpayer, unless it's an objective appeal, the taxpayer may only request a review of the current year's assessment. And after the informal conference, hopefully everything can be resolved satisfactory at the informal conference. But if not, then the assessor will make a recommendation regarding the appeal, either denying it or approving it, could be in whole or in part. And if it is denied in whole or in part, then it will be forwarded to the PTABOA for review. And just as clarification or reminder that if after the PTABOA makes their determination, either the assessor or the taxpayer can file an appeal of that decision to the Indiana Board of Tax Review. And after the appeal is heard at the Indiana Board of Tax Review level, taxpayers and or the assessor can also appeal that determination to the Indiana Tax Court. There were several legislative changes that occurred this past legislative session, and some of those were in our bill, House Enrolled Act 1454. And the first change that occurred is in response to the Schiffler decision and changing the homestead, or what is eligible for the homestead deduction. And there was some misinformation or some ambiguity in terms of when could a taxpayer, or how long could a taxpayer file an appeal on the changes in the homestead or the tax caps. And the legislation specifically stated that a taxpayer could file an appeal only going back for in this case, the January 1st, 2023 assessment. So a taxpayer has until December 31st of this year to file an appeal regarding the tax caps and the homestead deduction. Some people thought, because it was, as I referenced a minute ago, an objective issue, some people thought that a taxpayer could go back up to 3 years, and that's not the case. For the change in the homestead deduction and the tax caps, taxpayers have until December 31st to file an appeal. In terms of any other matters, that are related to the assessment, those are still subject to the provisions found in Indiana Code 6-1.1-15-1.1. Another change in the assessment practice or the appeal process in our bill dealt with assessment appeals and changes in the assessment. And specifically that the assessment, either as a result of the informal meeting between the assessor or based on the PTABOA hearing, that assessment may be less than or equal to the original appealed assessment, but it may not exceed the original appealed assessment that is being debated. However, there is a caveat to that, in that if the increase in the assessed value is attributed to say renovations, new construction, or zoning changes or a change in use, that those would be excluded from the limitations. And this would be only applicable to appeals before the PTABOA. House Enrolled Act 1449 dealt with appraisals, and specifically it states that if a taxpayer presents an appraisal to the PTABOA, that appraisal is presumed to be correct, assuming a couple things. One is that it's prepared by a certified appraiser in compliance with use PAP to determine the market value and use. Two, that it's addressed to the property owner or the assessor's office. Three, and this is a key thing, it's commissioned for the purposes of the assessment appeal. And four, it's marked with the effective date that is the same date of the assessment, the subject of the appeal. So in other words, if a taxpayer had an appraisal done and it met those requirements, it would be presumed to be correct. That doesn't necessarily apply to, say, if a taxpayer came to the appeal process with an appraisal that was done for, say, estate planning purposes or part of a divorce or refinancing, whatever the case may be. The PTABOA may also seek a review of the appraisal or obtain their own independent appraisal. So what's good for the goose is good for the gander, so to speak, for appraisals. And as I mentioned a minute ago, after the PTABOA decision, both parties retain the rights to appeal to the IBTR. Our bill also amended the requirement in regard to the majority of the PTABOA, excuse me, that in order to constitute a quorum, that must include at least one certified level 2 or 3 assessor. In terms of the PTABOA from a county, excuse me, the PTABOA from a county perspective, a county can have either a 3 or a 5 member PTABOA board, and that determination is made by the county. Some counties have found that it's better to have a 3-member board because of just trying to find qualified individuals to serve on the board, while others find a 5-member board might be preferable because, you know, trying to get a quorum, for example, it's easier to have 3 of the 5 members show up for a board meeting versus 2 of the 3. Excuse me, I'm getting over a cold. The Indiana law statutes also allow for the creation of multiple county PTABOAs, and this has been in existence for a while. I'm not aware of any counties that have taken up the opportunity to have a multiple county PTABOA, but if there were, for example, in the southeastern part of the state, maybe Ohio and Switzerland counties decide to create a multiple county PTABOA, that would be an example of counties coming together because maybe they can't find enough people to serve on their PTABOAs, and the synergy of the 2 or 3 or 4 counties would make it beneficial to have a multiple county PTABOA. There are certain requirements for the PTABOA members, but the one key thing is, be it an appraiser or a real estate agent or just a regular taxpayer person, is they should be knowledgeable in the valuation of property. There's no litmus test to test their knowledge, but hopefully your members on the PTABOA are knowledgeable in the valuation of property. As far as the 5-member PTABOA board goes, the commissioners appoint 3 members and the county fiscal body or county council appoints the other 2 members. At least one of the members appointed by the county council or their fiscal body must be a level 2 or 3 assessor appraiser, and at least one of the commissioners' appointments must be a level 2 or 3 assessor appraiser. However, both the county commissioners and the county fiscal body may waive that requirement. For a 3-member board, the fiscal body appoints 1 individual, who must be a level 2 or 3, and the commissioners appoint the 2 freehold members. And at least one of the commissioners' appointments must be a level 2 or 3, and much like we saw with the 5-member board, the commissioners and the council may waive that requirement. For multiple county, excuse me, multiple county PTABOAs, it encompasses the entire geographic area of the counties, and you can see there are certain political restrictions in terms of being from the same party, depending if it's a 3 or 5-member board. And also the ordinance must be passed by the counties in regard to the members on the PTABOA, multiple county PTABOA. Members on a multiple county PTABOA must be 18, much like for the other 3 or 5-member board, and they also must be knowledgeable in the valuation of the property. There are certain restrictions in terms of who may not be a member of a multiple county PTABOA. That includes an elected county official, an employee of a county or township that is within the geographic area of that multiple county PTABOA, and an appraiser that resides in that geographic area. Compensation is determined jointly by the fiscal bodies of the participating counties, and the county assessor that has the greatest population would be the entity responsible for providing the administrative support. I apologize, getting so choked up about all this. As far as certain requirements for the PTABOA, the Indiana Code citation you see there requires that there be an annual meeting of the PTABOA, and there must be at least two weeks notice given before the meeting is held. Most counties that have their annual meeting will hold it typically in January, after the county council and the county commissioners make their appointments in usually November or December. There's no time restriction or time frame for that annual session to be held. Could be held in July if you wanted to, but there should be an annual session meeting of the PTABOA. As far as the actual practice or information about the appeal process, if either the taxpayer or the assessor provides information for the first time at the PTABOA hearing, the PTABOA shall give a continuance so that each party or the party has a chance to look at the additional information. This is sort of like, if you remember the TV show Perry Mason, we don't want a smoking gun or some surprise development to show up and the other party not have a chance to look at it and examine the information that's presented. However, the person or the party receiving the information can waive that continuance if they so choose. Regardless of that, the PTABOA is required to give at least 30 days notice of the hearing to the taxpayer. If the taxpayer and assessor agree to a shorter notice period, they can, but it should be at least 30 days. If more than 180 days have passed since the taxpayer filed an appeal, I apologize, I'm sorry about that. If more than 180 days passes since the appeal was filed, and the PTABOA has not issued a determination, a taxpayer may, not required to, may initiate an appeal with the Indiana Board of Tax Review. Some taxpayers may find that they're having a better opportunity to get their situation resolved at the local level, and they're not concerned about that 180 days. Other taxpayers may say, hey, the county had their chance, they blew it, I'm going to proceed and go to the IBTR and take my chances there. If a taxpayer and assessing official say, hey, this is not going to be, we're not going to get this resolved at the local level, we want to take it straight to the IBTR, they can agree to waive a determination and take it directly to the IBTR, and they stipulate to the assessed value determined by an independent appraisal. And I'm not aware of too many taxpayers or assessors doing that, but that is an alternative if you have a situation where the assessor and the taxpayer just can't come to an agreement and they say, let's just take it straight to the IBTR. That is permissible. As far as appeals and confidential information, there is obviously, especially with commercial and industrial properties, a chance that there could be confidential information presented. And if the PTABOA receives confidential information, the PTABOA must maintain the confidentiality of that information, that record. The PTABOA can go into executive session to discuss confidential information, even though the PTABOA meetings are to be public meetings. There is an option under the open door law where the PTABOA can go into executive session to discuss the confidential information. However, the PTABOA may not take final action during that executive session. The open door law covers the PTABOA meetings, and that's designed to ensure that meetings are open to the public. And as you can see, the PTABOA is subject to the open door law. Basically, the PTABOA meeting is just the gathering of a majority of the members for the purpose of taking official action on official business. I mentioned the 30-day notification to the taxpayer for the hearing, but as far as the actual meeting, the meeting must be advertised and public notice must be given at least 48 hours in advance of the meeting in terms of the date, the time, and place for the meeting. So I mentioned official action. What is official action? And as you can see, it's fairly broad. It can include receiving information, deliberations, recommendations, establishing policy, making decisions, and taking final action. One of the questions we receive on a fairly regular basis is, well, how much should we pay our PTABOA members? And that is going to be determined at the local level. And especially at this point in time of the year, our budget division is working with all the local units of government. So this would be a good time to look ahead to next year in terms of what should the compensation be for the PTABOA members in terms of setting the budget. The county council fixes the rate of compensation. The county assessor, who serves as the secretary to the PTABOA and a non-voting member of the PTABOA, keeps an attendance record, and then they in turn will certify the attendance, the number of days served, to the county commissioners. In some of the larger counties, the PTABOA may want to hire an additional field representative or a hearing examiner to help with performing its duties and functions. That's fine. The key thing is the representatives and examiners must be level 2 or 3 certified. They cannot have that waived by the county council or county commissioners. And the number and compensation for those representatives and examiners is determined by the county council. They are afforded the same powers, so to speak, as members of the PTABOA in terms of the review of the assessments. However, they report their findings to the board in writing, and the board can then accept or reject the representative's recommendation, or the PTABOA can go ahead and hold further hearings and take additional evidence if they so choose. And the board makes the final decision, obviously, on each matter. And the reason why PTABOA may want have a hearing representative or examiner if they are overloaded with appeals and looking to help the workload or make the workload a little bit easier. That's why they may hire a representative or an examiner to help out. So if you're a PTABOA member, welcome. We're glad you're participating, but you have certain powers entrusted to you. One is you can subpoena witnesses. You can examine witnesses under oath. You can compel witnesses to answer your questions. And also you can order the production of relevant papers. A change a year or two ago involves the PTABOA submitting a report to our office and Legislative Services Agency through our gateway system. Prior to a year or two or so ago, it used to be due April 1st, and that was changed to January 15th annually. And what this PTABOA report reflects is what all the appeals that occurred the prior calendar year and what is the disposition of those appeals. How many were settled at the local level? How many were settled in favor of the taxpayer? How many were settled in favor of the assessing official? How many are still pending? How many have been appealed to the IBTR? How many are still pending at the IBTR level? So that report is due January 15th every year. The county assessor is typically the person that submits that report. The golden rule applies, I think, and it should apply uniformly throughout the appeal process. If you're a PTABOA member, you should be treating the taxpayers or other assessing officials, whomever, how you would want to be treated. Just, I guess, goes without saying, common sense. And even though the PTABOA is not a trial per se, the PTABOA members should conduct themselves the way any judge would in any hearing. And then also PTABOA members should be cautioned to avoid conflicts of interest if at all possible. And specifically, if you do encounter a situation with an appeal and you have to just remove yourself from that determination, that's fine. It happens. So what about the hearing itself? So we talked about that the assessor should be handling or having an informal hearing. Hopefully the PTABOA then schedules a hearing not later than 180 days after the filing petition date. We talked about if they don't, then the taxpayer has the right to file an appeal with the IBTR. Talked about the 30-day notice being given, and that should be given to the taxpayer, or if the taxpayer has a tax representative, the assessing official, and the county auditor. In some situations, there's a need for a continuance, and that may be due to scheduling or work things, whatever the case may be. A request must be filed at least 10 days before the hearing, and when the request is granted, if the request is granted, then the PTABOA shall then reschedule the hearing, again giving that 30-day notification. In some situations, the taxpayer may want to withdraw their appeal. Perhaps they filed an appeal just to make sure they covered their bases to begin with, and after they've had a chance to look at things, they decide, I don't want to pursue my appeal, and they can withdraw their appeal. That's fine. However, they must do it in writing at least 10 days before the PTABOA hearing, and once that is filed, then the PTABOA will issue a final determination indicating the withdrawal and that there's no change in the assessment. A key thing that taxpayers should be aware of is that they do withdraw their appeal, they waive the right to appeal to the IBTR. So if the taxpayer says, I'm not going to pursue it, that's fine, but they cannot then try and go to the IBTR at a later time for that appeals year. If good cause is shown, the PTABOA we talked about a continuance. Hopefully you only have a taxpayer asking for a continuance once. There may be a situation where maybe they have to do a second time, but anything after that, I would be asking the taxpayer, why do you need so many continuances? But if there is a continuance granted, then make sure it's done 10 days before the hearing and then reschedule the hearing. So at the PTABOA hearing, certainly the taxpayer has the opportunity to present their testimony and evidence. If there is an issue involving the county auditor, say a homestead deduction was denied, for example, the auditor or the auditor's representative shall attend the hearing. The assessing official certainly would then, or the auditor would then obviously have the opportunity to present their testimony and evidence in regard to the assessment or the appeal issues. Equal time should be given to both parties, and then the PTABOA may then adjourn and continue the hearing, make a physical inspection if they want to. I wouldn't suggest that, just due to time and money, and then consider any of the evidence presented. So the PTABOA shall just make a determination of the assessment by motion and majority vote based on the evidence before it. We'll talk a little bit, like I said, about evidence here in a minute or two coming up. The PTABOA may increase an assessment, but only in those situations like I referenced earlier with the legislative change. And then the PTABOA then issues a written decision to the taxpayer, and then the taxpayer, then if they disagree, may appeal to the IBTR, or if the decision is not made within 180 days, they could appeal to the IBTR. In some situations, you may have a taxpayer representative that fails to appear at the hearing. Well, what do you do in those situations? This is strictly a county option. But the county assessor may impose a $50 penalty to the taxpayer. The taxpayer may appeal that penalty to the IBTR or to the tax court, and it's not part of the tax bill. That's one of the key things. It would be administered, collected separately from the tax bill. A couple of years ago, there was a legislative change in regard to who may represent a taxpayer in a property tax appeal, and the premise was, hey, could a relative of the property owner, appear before the PTABOA, maybe a father or a son or a grandparent, and that was changed so that a relative could represent the taxpayer. They do not need to be certified as a taxpayer representative to represent the owner. If it gets appealed to the IBTR, that they have different specific rules regarding the powers of attorney, and so that may or may not be applicable at the IBTR level. So you should consult the IBTR's website as far as who may represent a person at the IBTR level. So you're a board member and you have an appeal before you, and so how do you determine, hey, is the taxpayer correct in his or her arguments? And obviously this is going to be on a case-by-case basis as the evidence, is presented. One thing I would suggest is maybe you going online and reading prior IBTR decisions or tax court decisions that maybe address various issues that you may encounter, say apartment assessments or income producing properties or something like that, just to become familiar with various assessment processes and decisions that have been made. So I mentioned counties deciding, do they have a 3 or a 5-member board, and one of the questions that's come up is if you're having a difficult time finding qualified individuals to serve on the PTABOA, can the prior assessor serve on the PTABOA? And we're not aware of any statutory provision that would prevent a former assessing official from serving on the PTABOA, but from the court of public opinion, it may not look good, or a taxpayer may walk in and see the former assessor serving on the PTABOA, and they may say, how am I going to get a fair shake in my appeal process if the prior assessor is on the board and they're hearing my case? Am I going to get a fair determination from that person or not? So there's nothing preventing it, but hopefully you can maybe find somebody else that could serve instead of the prior assessor. So when can a decision be made? Well, obviously, it's basically the board at their meeting can make the determination as soon as they have all the information and there is an agreement by a majority of the board. In terms of evidence, I mentioned we're going to talk about evidence. What type of evidence is required in the appeal process? And there are a variety of things that can be brought to the appeal hearing, the appeal process. One of the biggest things is a USPAP compliant appraisal. And I do want to note and make sure everyone is aware that an appraisal is not required in the appeal process. Some taxpayers believe that, oh, in order to appeal my assessment, I need to have an appraisal done. That is not a requirement. An appraisal, USPAP compliant appraisal is an opinion of value, and it very well may be something that gives great evidence documentation to why the assessment may be incorrect, but it is not required. Some taxpayers may bring actual construction costs to the appeal process, but make sure that both the direct and indirect costs are included. Indirect costs would be things like building permits or architectural fees, something like that. Certainly, if it's an arm's length transaction, the sale of the subject property would be the best indication of value, but you need to make sure that it is a valid sale and that it is an arm's length transaction. And the final thing the taxpayer may bring is just a sale of comparable properties. And that a lot of times in the appeal process is where there's a great deal of deliberation. What is or what is not a comparable property? In regard to determining whether or not it's a comparable property, that's you're to use generally accepted appraisal and assessment practices to make that determination. In regard to the evidence and how do you present the evidence, what's presented, you can see there are 2 court cases and 2 quotes from those court cases involving the evidence. The first is, a party must explain how the evidence relates to the appealed property's market value and use as of the relevant valuation date. And also, the taxpayer must explain how each piece of evidence relates to the requested assessment. The assessor can't just look at the evidence and say, yeah, I don't agree with it and I don't think it's valid. They just can't brush it off, so to speak. They have to be able to decide or determine or state, here's why I'm challenging the evidence or documentation or information that was submitted. Maybe it lacks credibility because it was not USPAP. It was not a USPAP compliant assessment or appraisal, or maybe the comparable sales really aren't comparable, or maybe the income and expense information had expenses that were not allowable. Whatever the case may be, but the assessor just cannot simply diminish or dismiss the evidence and say they don't believe it's valid. There must be a reason behind it. Appraisals are, I mentioned, an opinion of value, and any adjustments should also be made, or any adjustments to those, the sales used in the appraisal should be reviewed and analyzed. And the adjustments could be if a property had a basement versus not having a basement, how much was an adjustment made, or if it's a corner lot versus middle of the subdivision lot. Things like that. So adjustments can be a very important part of a comparable property or sales comparison. I mentioned income and expense information for income producing properties. So those should be reviewed carefully. And some types of properties, say like golf courses, for example, they are statutorily required to be used or to use certain assessment methods, such as the income approach. So who can file an appeal? Well, obviously, the taxpayer of record on the assessment date would be the person filing the appeal. However, the Indiana Board of Tax Review has previously ruled that if a taxpayer did not own the property on the assessment date, but they were responsible for the property taxes due for that assessment date, they would have standing to file an appeal for that property. As far as best practices go for the preliminary hearing, can the assessors have a set amount of time for each preliminary hearing? Sure, say 15 minutes or a half hour, whatever the case may be. There's no requirement, but to keep things moving and to make sure all the appeals are addressed timely, probably makes sense to have a set amount of time for the preliminary hearing to be conducted. This is one of those local control issues. So the assessing official can determine, here's how much time we're going to set, here's when the hearing is going to be held, and any other procedures for that preliminary hearing. Can a CPA file appeals on a taxpayer's behalf? A CPA is not considered a tax representative. Hence, they would only be able to represent a taxpayer in matters that pertain to personal property assessments. Timing is a big thing, and this gets into the Form 11s versus the tax statement. So the taxpayer must file a separate petition for each parcel and can be filed any time, but not later than the following. If an assessor sends out a Form 11 notice of assessment by April 30th, say April 30th, 2023, a taxpayer would have until June 15th of 2023 to file an appeal for that assessment year. If for whatever reason the assessor does not send out a notice of assessment by April 30th, before May 1st, and the tax notice or the tax statement serves as the notification of the assessment, then the taxpayer would have until June 15th of the following year to file an appeal. So in other words, if a taxpayer or if the assessor did not send out the notice of assessment by April 30th of 2023, and the tax notice was the first notice of assessment, a taxpayer would have until June 15th of 2024 to file an appeal for the January 1, 2023 assessment date. We've had a couple of issues come up. Our office started reviewing and improving Form 11s, and we've had a couple of issues come up where the taxpayer or the assessor stated on the Form 11 that they can only appeal the total value, the total assessed value, and then they could not appeal only land or structures. And the Indiana Board of Tax Review has usually discussed in its decisions that it does not prefer to consider only land or improvements when reviewing assessments, but they have had a couple of cases where they did appeal or analyze the appeal based on land and or improvements. So a county should not be making the statement that, hey, you're only appealing the total value. You cannot appeal just the land or just the structures. And the county, obviously, the county assessor should review all appeals submitted. As Jenny mentioned at the start, we've received a few questions, so I'll go through some of the questions we received, and then also, if you do have any questions, please submit them in the Q&A box at the top, the bubble that Jenny mentioned. So the first question is, for a 5-member board, can we still hold hearings if only 3 are able to attend? And the answer is yes, as long as a quorum exists. Also, as I mentioned, House Enrolled Act 1454 amends the code provision, removing the requirement that the majority of a PTABOA, in order to constitute a quorum, must include at least 1 certified level 2 or level 3 assessor. However, there is still the requirement that the PTABOA must have at least 1 certified level 2 or level 3 assessor, but that requirement can be waived by the fiscal body or the board of county commissioners. Another question was, how does a level 3 assessor inquire about open positions for the PTABOA? And by that, I'm assuming that the person that is interested in serving on a PTABOA, that person should reach out to the county assessor where they hope to serve, to see if are any vacancies, and also to see if it potentially would be a good fit. Also, an individual could reach out to the appointing body, say the county fiscal body, and or the board of county commissioners to see about an appointment to the board. Should members of the PTABOA strictly review evidence presented, or are they allowed to review multiple listing service listings and other approved sources to reach a determination? The appeal really should be determined on the evidence documentation presented. In the course of that evidence or documentation submitted, maybe somebody does submit MLS listings or what other information they may submit, but the determination really should be made or based on the evidence and documentation and the testimony presented at the hearing. Another question that came in was, why are the taxes so inconsistent from property to property? And this is a good question, and we get this a lot from taxpayers. Why is my neighbor's property tax bill different than mine? Well, it depends obviously on the assessed value. And then also, are there any deductions that one taxpayer may have, another one does not, say the homestead deduction, for example, and what are the tax rates? We've had situations where taxpayers could be across the street from each other, and based on the taxing district boundaries, they have different tax rates. So there's several reasons why the taxes may be inconsistent from property to property. Another question that came in was, a person was needing some answers on the age deduction as far as the overrides for the over assessed values. That's more of a deductions question, and just a plug. Next month, Wednesday, October 18th, we will be having a webinar on deductions and exemptions. So that might be a better class webinar to ask that question. I did have a couple other questions, Jenny, before I turn it over to you to see what questions may have come in. First one is, does the council and commissioners have to appoint members, or is that a local control thing? The answer is yes. Per Indiana Code 6-1.1-28-1, which covers the Property Tax Assessment Board of Appeals, the council and commissioners are the ones that appoint the members. A follow-up then was to that is, if they do have to appoint them, how would I go about letting them know this? Would I bring it up to them at a meeting? And I would suggest contacting the county commissioner president and also the county council president to let them know about the appointment requirements. And I say this frequently, you may also want to consult with your county attorney for legal advice in terms of the appointment process. Final question is, should the assessor be conducting the PTABOA meeting since we are the secretary? And my response to that is, this would be a local control decision. However, the PTABOA president would really be the one who should be conducting the meeting, because they are the president of the board, and they would be the ones in any other meeting situation. The president of that board or that committee would be the one conducting or running the meeting. So with that, I'm going to show you my contact information. If you do have any specific questions that I can hopefully help you with, please reach out to me and contact me. But Jenny, did we have any questions that came in during the presentation?
Yes, we did. We had a couple. The first one is if a 2021 appeal has been ruled on by the tax court and a new opinion under a different petitioner has been rendered on a similar case, which could cause the initial ruling to change, can the petitioner appeal this decision a second time?
That is a good question. I don't know the answer off the top of my head, and I would hate to venture a guess without knowing a little bit more background. So I'm going to defer and say we'll leave that for the FAQs that you mentioned, Jenny, at the start of the webinar, and we'll address that in the FAQs. I would need to check with our legal staff to make sure we answer that appropriately. So I apologize, not able to answer it right here and now, but better safe than sorry. So sorry. Jenny, next question.
Sure. Our second question, if a petitioner filed an appeal on a vacant parcel in 1 year and the next year split that parcel into 2, would they carry the burden on the appeals even though they raised by over 5%?
I would think so, and the reason I think so is because there had been some action taken to change that original parcel from 1 to 2. So yes, I believe so. But we'll follow up and make sure we answer that officially in the FAQs.
Great. And our last one that we've got submitted so far is an assessor reclassifies an existing agricultural property to commercial without notice to the taxpayer. Is this considered an objective appeal when there has been no change in the use or improvements to the property for decades?
My initial reaction would be that it would be an objective appeal. I mentioned, can it be answered in a yes, no, or true, false manner? And so if I'm the taxpayer and I appeal, am I saying, the assessor changed the classification from agricultural to residential, commercial, industrial, whatever the case may be? Is that an objective or a subjective issue? I'm going to flip-flop. I said objective, I meant to say subjective. And the reason I say subjective is, I could look at a parcel of land, you could look at a parcel of land that may be vacant, but I may know that there was zoning change to it. So I'm going to say subjective in terms of the determination on whether or not they can go back up to 3 years. I'm certainly would encourage the assessing official to send out a notice of assessment notification to the taxpayer saying we've changed the classification of your property from agricultural to commercial, residential, whatever it may be, and then allow the taxpayer to appeal that way. But with that change in classification would also be a change in the valuation, probably, or we've had situations where property may have been in the developer's discount and it's taken out of the developer's discount and put into commercial or residential, and the key there being change in use, and then also looking at the assessed value. And so I would go subjective in that situation, but we will confirm that in our responses. So.
Great, thank you, Barry.
Sure.
The last question I'm going to actually take is this presentation being recorded? Yes, it is. You will receive a link to that with the email that you will receive at the end later this week. It'll have the presentation, the PowerPoint format, the PDF format. We've got a video, the survey link, and the CE form. So you'll be able to review this later. It will also be posted on the DLGF's website and the DLGF YouTube page. So you can go back and rewatch those or share that with anybody else within your office or other members that may not have been able to be present. As Barry mentioned, and I mentioned earlier, we will take all of the questions that we've received, including ones that we may receive later today. We'll include that in an FAQ that we'll put together, so you'll be able to review that as well. That will be posted on the DLGF's website on the webinar page, along with the presentations. So just as a reminder, you'll get an email. It'll have the PowerPoint, the video, the survey, the CE form, and we do really appreciate the information that you provide on the survey. As we are starting to plan for 2024's webinars, we do take all the feedback that we receive throughout the year and look at common or frequent requests or frequent topics. So if you do have a topic that you would like us to see covered next year, please feel free to send that to me, and we'll get that added to our list as we look through our submissions and try to plan out for 2024. And hopefully that we will be able to see you at our webinar in September. Not September, it's September now, in October. And you'll be able to join us there and enjoy that presentation by our legal division on deductions. So we will hopefully see you next month. And thank you again for joining us today. Yes.
Jenny, before we sign off, I just saw another question come in. So we got a minute or two, so I just want to address it real quick. Is the assessor allowed to view the petitioner's evidence before it presents its case before the PTABOA? And this goes back to what I talked about with the the preliminary conference and exchanging information. So I would think definitely yes, the assessor could review the petitioner's information evidence, as well as the petitioner reviewing the assessor's information as well. So it goes both ways. So hopefully both sides are aware of the information presented. And as I mentioned in the presentation, if for whatever reason a taxpayer or the assessor presents something at the hearing that's new and it wasn't previously disclosed, then the other party does have a right to have a continuance and a delay in reviewing. So a delay until they can review that information. But simple answer is yes, the assessor can review the petitioner's evidence. So just wanted to get that in before we signed off. So.
Great. Well, thank you, Barry. And again, thank you all for joining this month, and we will hopefully see you next month in October.